and we're going to go ahead and get started. So the topic, marijuana in the workplace. Presenter again, Rhonda Stevens from BBSI, and my name is Tyson Fuhrer from Biggs. I handle the compliance side of things, which has to do with mainly healthcare, but also some of the other health-related items that HR people are having to maintain. Our contact information here, and it's going to be at the end as well. So feel free to reach out to us if you have a question that you want to ask specifically via phone or email. So go ahead, Rhonda. Go ahead and start on the presentation there.
Okay, thanks, Tyson. Hello, everyone, and thanks for joining us. As Tyson mentioned, we have a pretty short period of time here, so I'm going to jump right into the slides and, again, try to save time for questions at the end. So current state, I'm going to talk a little bit about where we are now with legalized marijuana and how we got here. So currently, 23 states plus Washington, D.C. have legalized medical use of marijuana. And then the more recent trend is for recreational use of marijuana, and there are currently 4 states plus Washington, D.C. that have allowed that. Now, Oregon actually doesn't go in effect until July 1st, which is right around the corner. But in Alaska, I'm not sure actually, because I think they were the most recent one to adopt, and I'm not 100% sure when their effective date is. But there's rumor or predictions that at least 6 more states are going to legalize recreational marijuana in 2016. So let's talk about a little bit about kind of semantics. So legal versus decriminalized. It's pretty prevalent to use the word legalized when it comes to what the states are doing with marijuana, both medical and recreational. But that's not exactly accurate, because really states can't legalize something that's still illegal under federal law. So what the states are really doing is they're decriminalizing the use of marijuana, which means basically protecting against criminal prosecution. So decriminalizing is really a better word to use, although I think it's, again, legalizing it is kind of the prevalent term. So as far as the federal law goes, the Controlled Substance Act of 1970 criminalized the use of marijuana as a Schedule I substance. So controlled substances, you know, a lot of prescription drugs that are legal under prescription are in these schedules, but Schedule I happens to be the schedule of drugs that it has been determined there's no medical benefit. So so that's kind of the basis for the fact that it's still illegal under federal law. It has not been removed from Schedule I at this point. It's worth mentioning that there's currently a bipartisan bill that's gaining a lot of momentum for removing marijuana from Schedule I and putting it into Schedule II, which Schedule II are drugs that are thought to or known to have some sort of a medical benefit. As it stands right now, with the whole thing being still illegal under federal law, and we'll get into this in more detail, but it may not seem like a cut and dry issue, but it makes it a lot more cut and dry as to how this affects the employment relationship than it will if, in fact, they decriminalize it at the federal level. That will be a whole new conversation that we may be having in years to come. But we're gonna approach it right now from the standpoint that it's still illegal under federal law. So with the trend, and this has been going on for quite a few years, of states decriminalizing marijuana for medical purposes, the Department of Justice in 2009 came out and said, basically, we're not going to waste a bunch of resources going into states who have decriminalized and try to do anything there. So they've taken a very relaxed enforcement stance on using the use and the possession and all the things that the states allow in those states. So given the conflict between federal and state law, there is naturally a lot of uncertainty about how the impact on workplace policies and employment laws, how it applies to those things. So on the next slide, medical use versus recreational use. Is there a difference when it comes to the workplace? Not really. From a legal standpoint, there really isn't a lot of difference as far as what employers are able to do and not do, but the implications and factors to consider in what employers are going to do or should do are very different. So we're going to talk a little bit more about that in future slides. One second, I lost my screen here, so I'm going to take a second to log back in. Bear with me. Okay. So the next slide, so we're going to talk for a few slides about medical marijuana in particular because it's kind of the more complex issue. And it's the more prevalent decriminalization since you've got 23 states versus 4 basically for recreational. But again, we will hit recreational. So a few of the laws that have, I guess the most amount of implication with the medical marijuana issue would be the Drug Place Work Act, which is applicable to federal contractors. So I don't know if there's anybody on this call that is under a federal contract or that this would apply to, but so I'll just cover it briefly and then put it in questions if you want more information. But basically, there are still requirements under the Drug-Free Workplace Act for federal contractors to take all these steps to make sure that they are providing a drug-free and safe workplace. So that is in direct conflict with, accommodating the use of medical marijuana in the workplace. Workplace safety, OSHA's General Duty Clause requires employers to provide a hazard-free workplace. Obviously, use of marijuana at work or even around work hours in certain positions can cause a lot of problems. And so, that needs to be looked at very carefully. In fact, the Department of Transportation, even if it's in the state level, and the state agencies have taken a no tolerance stance, which they're allowed to do, saying we will drug test, we have no tolerance, you can't do this, we've got drivers. So obviously that's one of the environments and driving positions where it's just not, it's too risky for employers to even even go no tolerance and consider accommodations. The Family Medical Leave Act, this has come up a few times. Basically, the thought is that leave is not covered for, I guess, the use of marijuana. So let's say that somebody, has a condition, and it may be a serious health condition under FEMLA, but they want to take leave or they request leave because they need to go through marijuana treatment. They know they can't be impaired at work, so they request leave under FEMLA. And so far that, there's no question that does not need to be accommodated. The leave does not need to be approved. Now they may qualify for leave because of the condition for different types of treatment, but certainly not marijuana. The most applicable employment laws, Americans with Disabilities, and a lot of the case law has focused on this very particular law. And in most states that have legalized medical marijuana, the stance is that, or the courts are ruling, that employers may prohibit illegal use of drugs in the workplace. And there may be an underlying condition that they're using the marijuana for that's even listed on the approved condition state by state. And while that condition may be ADA covered, it's found that the use of marijuana to treat symptoms is not a reasonable accommodation. So illegal drug use does not include the legitimate use of a prescribed drug. And actually, that probably shouldn't say prescribed because marijuana actually isn't prescribed, it's recommended. Right now, the ADA does not recognize it as a drug, has not approved it, so it can't be prescribed, just recommended by doctors. Underlying condition for which marijuana is prescribed may be protected. So the main thing is that employers need to be careful in how they approach any sort of a request or any sort of indication from an employee who says, hey, I need or I'm using marijuana because I have this condition. So while you don't have to accommodate it, and in fact, most case law says that you can actually fire people for using marijuana, you still have to be really careful about how you fire that person, why you fire that person. It can't be based on their actual disability, and I would say that employers really need to go ahead and enter into the interactive process with with an ADA condition and talk about other possible treatments, and then ultimately come to the conclusion, well, this is the only thing, and no, we can't accommodate that. So a little bit about the laws in Oregon and Washington. I'm going to focus on Oregon and Washington. I think that everybody on this webcast is an employer in one of those two states, so that's where we're going to focus. So in Oregon, medical use under the Oregon Medical Marijuana Act, or OMA, allows growing, possession, or own use for certain debilitating conditions, and there is no statutory reference to employer accommodation. So the standout case law with the Oregon Supreme Court, Emerald Steel Fabrications versus Boley, confirmed that employers are not required to accommodate the use of medical marijuana under OMA, that companies can fire for positive drug tests, even if the person has a valid medical marijuana card and an underlying ADA protected disability. State law does not override a legal status under federal law, and state employment discrimination laws do not require accommodation of the use of medical marijuana. So recreational use in Oregon, which passed under Measure 91 last November and becomes effective next month, doesn't change the fact that employers can fire, and in fact it better supports that employers can fire people for using marijuana or testing positive, if you have a random drug policy, or maybe not hiring if you have a pre-employment drug screening. I think what complicates things with the recreational use becoming decriminalized is that it's just going to be more widespread. And so you don't have to have, an underlying condition that you can get a registry and you can get a recommendation from a physician. Anybody can kind of go out and buy this and do this, and they do it on their own time. And so how does that and how should it affect what employers do as far as the workplace? And that is going to be a big question, employer by employer, because it's going to become more widespread and probably lose a lot of the stigma, and you're going to hear about it more. Even maybe people who are already using it, now we're going to just talk more about it. It's a matter of, if you have a no tolerance policy, is that going to affect your ability to hire and retain people that you want to hire and retain? And so, that's just something that I think each company has to look at the way, look at their, the people that, the positions that they're recruiting for, and, how far do they want to accommodate this, and, kind of think about it really as, well, I mean, it's a little bit like alcohol. It is and it isn't. I mean, what's hard about it is that if you have a drug test policy for, for certain positions, and then somebody turns up positive, then you have to start wondering, okay, does that mean they were impaired at work? Are they unsafe? And so we're going to talk a little bit more about the impairment issue and different types of testing that will hopefully be helpful to answer those questions, or at least to give you a basis to start having the conversation at your workplace and what, deciding what you want to do. So next slide, in Washington, medical use of marijuana, or MUMA, allows patients who are suffering from terminal or debilitating conditions to use marijuana to treat symptoms. And like Oregon, the Washington law makes no reference to employment applicability. The case law for Washington is actually, I think, probably the most famous that there is so far, with this in any state. And it was Roe versus Teletech Customer Care Management, The Washington Supreme Court decided that MUMA does not prohibit an employer from discharging an employee for use of medical marijuana. It says that the state law provides only criminal defense, and it does not provide workplace protections, and employees can be fired for testing positive for marijuana. Recreational use under Initiative 502 passed in November 2012, so there's a little more time on the books in Washington than there obviously is in Oregon, since it's not effective yet in Oregon. But there's been no major cases come out for recreational use. But again, recreational use certainly doesn't give employees any more rights than, and really fewer rights than the medical use. But again, it brings up different issues as far as, is it going to become more widespread? Do we want to prohibit people from using marijuana on their own time? How does that affect them at work, or does it affect them at work? And part of the hard part of that question is that there's not a really good way of testing for intoxication. So again, we'll talk about that a little bit more here soon. So next slide, steps to take. Look at your drug policy. If you don't have one, then I would suggest that you should. There's kind of a sense out there that in some cases, don't have a policy, because then you're just going to have to enforce it. And if you don't enforce it, then you're in a worse position than not having a policy. But I do think that this is going to become a very frequent issue that employers are going to have to address, and you need a policy. So if you have a drug policy, look at it, update it. Again, there are going to be decisions to be made as far as, whether you go no tolerance or accommodate some out of the, off work time use of marijuana. And then if that's the case, how you want to really run your testing program. Is it going to be random? I mean, one way that it can be done is just post-accident or post-incident testing, maybe new hire testing. So those are things that employers are going to have to kind of sit down and make some decisions about, and think about the different ways that may affect their ability to hire employees, to retain employees. So create or update your policy. Be very clear about stating whether it's no tolerance. And if you state that it's no tolerance, you have to apply a no tolerance policy, even if it's even if it's something that in whatever case you really don't want to fire this person. I think that you're going to be putting yourself at great risk if you apply it inconsistently. Adopt simple, straightforward language covering use during and outside of work. Now, I think that any employer would want to prohibit use during. So, I mean, I think that's a given. But, what do you say about outside of work? And that really should be clear in your policy. And then also, are you going to distinguish between medical and recreational use? Maybe you want to provide some flexibility, for people who have the medical card to do it outside of work hours, but not recreational use outside of work hours. If accommodating, what positions should be excluded based on safety and cognitive considerations? Like I said, the Department of Transportation, they have drivers. They absolutely cannot have any positive drug testing for this. I mean, it puts them at great risk. And then communicate and require acknowledgement from all employees. And so this is something that I assume most of you are doing, for your policy handbook, and then when you update a policy, to make sure that people are acknowledging the policy. But I would even go further, either make it crystal clear, make the language very, very straightforward in the policy, or have meetings about it and just say, hey, here's what we're doing with it. What are the questions? Because the more that people understand what they're going to be dealing with, I think the better outcome as far as, when issues do come up. And then next slide, steps to take, training and other considerations. This is a big one. HR and supervisors should understand what constitutes reasonable suspicion of impairment. And you might want to consider adding some of that language to the policy. I mean, things like slurred speech and communication, any sort of abnormal or bizarre behavior, and hopefully supervisors or, HR or somebody has kind of a baseline with people so that they can easily determine when somebody's acting outside of their normal behavior. You know, unsteady gait. This is stuff that really could apply to any drug, and that's kind of a good thing, because you can really put this in your policy to, you know, apply to anything. I mean, it could be a totally legitimate prescription drug that somebody's taking. Somebody could be popping Xanax because of panic attacks. I mean, that's legitimate, you know, but can you have that in the workplace? Can that person do their job? You know, so I would say you would want to come up with some reasonable suspicion indicators, put it in your policy, and apply it, you know, whether you're suspecting that they're smoking marijuana or they told you that, you know, or you suspect maybe they're drinking or whatever, you know, prescription drugs. So, you know, HR should be and supervisors should be very aware of all these different factors, and, you know, that takes training and retraining. Supervisors and managers must be trained and retrained on handling outright and implied requests for accommodation. And this is where that ADA, you know, I guess kind of scary area comes in, because, again, even though, you know, most states are saying, yeah, you know, you don't have to accommodate under ADA because that's a federal law and it's not legal federally. If a supervisor just flat out says, what, you know, you're smoking pot and so you want to have that accommodated under, you know, the ADA, forget it, you're fired, because, you know, the supervisor may understand that you can fire people for that, but, you know, they probably neglected to do what they need to do under the rest of the ADA if there is a qualifying underlying condition. So either train them well, or just have your procedure be that, you know, any sort of mention, request, you know, implied request for accommodation goes straight to HR, somebody that's well trained in it. If the policy is left open to accommodation, update job descriptions, essential functions should reflect safety and cognitive requirements. Now, this can be really helpful and, you know, a good step to take, because if you are going to, you know, make certain positions, I guess, different than others, then you definitely need to be able to say, well, you know, your position is one that, you know, we can't accommodate, if you are going to accommodate some. That's really important. And then, you know, then just as far as the essential functions of a job, so that even outside of your no tolerance positions, everybody else still has to be able to perform the essential functions of their job. So if some sort of an accommodated use of marijuana is, in fact, making them not able to do the essential functions, then you have a whole different level of ability to address that even outside of a no tolerance policy. The next page has some sample employee handbook language. I'm not going to go over that in detail. You guys can read that. This is a pretty basic sample policy. Again, you know, you can choose to add stronger language about no tolerance. You can choose to say, you know, it may be accommodated, or for these positions, yes or no. You know, and you can also add that reasonable suspicion language into the policy. I think that's really helpful, so that, you know, if you do come up against somebody who you suspect might be using pot or anything else, you can say, you are displaying these basically symptoms and indicators that are in the policy that you acknowledge, and so we need to get to the bottom of it. So that is the end of the slides, and I'm hoping we have some good questions, because I know that, you know, as simple as this should be, because the answer is really, yeah, you know, employers don't have to accommodate this. It's very complex in reality, and I'm sure there are all kinds of specific scenarios that you guys might have in your head that I didn't cover.
So a couple of things just want to mention, and thank you, is we are going to send out a copy of these slides to everybody at the end of the presentation. We're also going to upload a link of the recorded audio as well.